So thank you for joining us today. My name is Steve Flame. I am a special advisor to the NIH Office of Translational Alliances and Coordination, and I'm also deeply involved in the process of reviewing applications that are coming in through the Centers for Accelerated Innovation. This is the first of a series of webinars that are designed to give applicants some better understanding of what we're looking for in some of the questions that are embedded in the application. Before we get started with today's webinar, I wanted to just take a minute to talk about question number 1. This is under basis for the project, and this question number 1 is requesting the applicant to describe the scope and nature of the problem the technology will be designed to address and to give a brief description of the solution. And there are some elements there that are discussed that we're looking for. Let me just say that this should be a relatively brief answer. The idea here is to tell us what the problem is that you perceive and how your technology solves that problem. We're also looking for what the market space is. In other words, who is the customer going to be, who's the user going to be for this technology, and drill down a little bit on that. And also, why is that going to be better than what's the current standard of care? This is not a scientific discussion here. This is designed to give an investor a sort of a high-level sense of what it is that your technology will do and how it will benefit, and then why would it be something that could be marketable in the long run. So for this first webinar today, we're going to actually drill in on question number 6, which is the details around intellectual property. And the speaker for today's webinar is Pam Cox. Pam is partner and chair of intellectual property transactions at Marshall, Gerstein, Borun, LLP, which is a law firm in Chicago. Before going to Marshall, she was a director of tech transfer for Indiana University, in the Advanced Research and Technology Institute. And prior to that, she was engaged in regulatory and clinical affairs for DePuy Incorporated, which is a Johnson & Johnson company. So Pam has lots of experience on both sides of the line with respect to intellectual property. The line being the line between academic and corporations. And so Pam is going to drill in on question number 6 around intellectual property. So Pam, take it away.
Hello, my name is Pam Cox, and I'm at Marshall, Gerstein and Borun. I'm going to spend some time talking to you today about intellectual property. And probably for the next 15 minutes or so, we'll be looking at what the application asks about intellectual property. We'll discuss the 4 main forms of intellectual property and how that might relate to your technology that you're asking for funding about. And then we'll look at what you might say about your intellectual property in your funding application, especially if you have no direct filings at that time that you're filing the application. So the question number 6 in the grant application deals with intellectual property, and it describes the application and the interaction between intellectual property and your commercialization plan. It would like to know how you've interacted with the Technology Transfer Office in protecting your intellectual property, and specifically looking for you to list various forms of intellectual property, patent applications, patents, trademarks. We'll go through each of these types of intellectual property. The important serial numbers, filing dates, status, and then if it's a patent application, to talk about the claims. And we'll get into a description about the claims and how you might address what you have in your filings. It's important to stress that question number 6 should not be left blank. And I mean, that goes without saying, and it seems rather obvious, but from what we hear, there are a number of applications that are not filled out here. And the importance isn't just to answer the question, but also to help explain what your intellectual property strategy is. So why is the intellectual property being asked about in the grant application? Why is this important? Well, it's important because it's relevant to your commercial success for your technology. As we know in the life sciences, there are a number of years and a number of dollars that need to be invested in order to get a technology from the benchtop through the R&D, clinical work, and to the marketplace. Often protection is necessary to incentivize that investment, and not just in the United States, but worldwide protection, or at least in the major markets where the technology would be applicable. So if you have intellectual property, that increases your likelihood that there will be not only an investment from the nonprofit sector, but also in commercializing the technology. If there isn't a proprietary position around the technology, it's much more difficult to expect the millions that will need to be invested to take it to marketplace to be able to be justified. And you know, when we look at commercial success, we're really looking at where the stage of your technology is in the life cycle of development. I mean, obviously there's a whole pathway to market ahead of you, and so the application's asking where you're at in that process right now. If the application has been completed and that question's answered with filings, whether they're patent application filings or other strategy that we'll talk about, that would suggest that there's been an investment in the intellectual property and a strategy commercialization plan around that. Often that's going to include working with your technology transfer office. They have the expertise to help explain what that type of strategy might look like and then how to implement on it. We're also looking for intellectual property information in the grant application because it's relevant to the development. So as you're going through the pipeline from R&D, initial stages, early phase testing, 0, and through phase 1 and on, you're going to be filing different types of intellectual property. And so to see what your status is going to indicate where you're at in that process. If there is no intellectual property, that is indicative probably of an earlier stage of development. There also may be information that's helpful in the type of filing that you've made or the type of protection that you're seeking as we look to see what the commercialization plan and the go-to-market strategy would be. So for example, if you're filing on a new use for something, the compound that you might be using that new use for is perhaps protected by someone else's intellectual property, or perhaps it's not. Maybe you're the one that came up with the compound as well as the method that you're interested in developing. So knowing what the metes and boundaries are of your intellectual property and the way that that interacts with third-party intellectual property to the extent you have that information is going to help the reviewers see where you're at in the development life cycle. It also may suggest that the reason that you're seeking the funding is to get certain critical data to be able to enable further filings or to support the filings that have been already made. So what is intellectual property? I like to think about this as this phrase that I've seen used, creations of the mind protected under law. So intellectual property is tangible property, intellectual property, excuse me, get a little ahead of myself, is intangible property. And so really when you're talking intangible property, it's not something you hold in your hand. The value of intangible property is in the idea. And I want to contrast that with the tangible property where I was leading to a second ago. That's more of a physical thing. So you think about you know, the physical manifestation of intellectual property, whether that be a compound or a prototype or a device or something like that. That would be the tangible property. The ideas that go into how to create that would be the intangible property. So there's 4 forms of intellectual property, and the various forms each have their own schemes of protection, and we're going to go through those: patents, copyright, trade secret, and trademark. And the details of those for the trademark and the copyright go way back to the founding of the country. Our founding fathers in our Constitution prescribed that we would promote the progress of science and the useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries. I think that is just fascinating that intellectual property has been important since the very beginning, and it's an underpinning for both the innovation that we have built the country on, as well as our ability to incentivize entrepreneurship and further development for the benefit of the public. So patent rights, we'll start with the first form of the 4 that we're going to talk about today. Patent rights cover new, useful, and non-obvious processes, machines, methods of manufacture, and compositions. So what does that mean practically speaking for this audience? We're typically looking at new compounds, methods of making those compounds, perhaps software, other aspects that would interact in the manufacture of a device, those types of things would be protectable by patent rights. Patent rights are protecting the functionality of something. They're not protecting things that are just generally occurring phenomena, laws of nature, abstract ideas, things like that. Those may find protection in other forms of intellectual property that we'll discuss in a minute, but not patent rights. So who files a patent application? Well, that's going to be filed by the inventor. We just mentioned the reference to the Constitution, and we know that first the right of a patent would vest with the inventor. Now, that's the person who comes up with the idea. He conceives or she conceives of the idea, the aha moment. That person often has an employment obligation or other obligation to assign, transfer, convey their intellectual property to their employer. So, perhaps it's the research institution that would actually be making the filing. But fundamentally, in the first step, the patent right vests with the inventor, the one who conceived the idea. Now, they don't have to be the one that reduced it to practice. Often, the reduction to practice might come at a separate step. It may be constructively done with the filing of the patent application, but the conception of the idea gives rise to the right. And it's important in the academic research environment to remember that the patent application needs to be filed before there's public disclosure. Now, there are some periods of grace in the United States and outside the United States, but it really should not be considered to provide a reliance in being able to protect if you were to go and publish or present before you've filed your patent application. The European market, for example, does not have a period of grace. And so with any technology in the life sciences area, that's going to be a major market. And it would be important to file an invention disclosure with your tech transfer office and investigate whether or not there is the need to file a patent application before you publish or disclose that information in an enabling way. So that inventor, or most likely the employer of the inventor, will be doing the filing before the first public disclosure. So let's say all goes well and we're zipping ahead probably 7 years or so and a patent is issued. They always issue on a Tuesday. That will allow protection for the claimed subject matter. So if you flip to the back of the patent, you'll see a section that says I claim, and then there will be a list of 1 through however many sentences. And those sentences define the metes and bounds of what the invention is, what the protection is. And what does it mean to have a patent application protect something? It gives you the right to exclude others for making, using, selling, offering for sale, and importing the claimed invention. So what's in those words, those sentences at the end of the patent application. Now, it does not allow you to do these things. And this is why patents are often called negative rights. They convey negative rights because it does not mean that you yourself will be able to make that invention or to sell that invention. There may be third parties who have aspects of your claimed subject matter that you will need rights from in order to go to market. And so that's why when we look at what does a patent do, a patent really allows you to stop others from practicing your technology. It does not enable or guarantee that you will be able to practice your technology. And knowing that it's not an affirmative right is important because that helps you start early on in your intellectual property strategy and your commercialization plan to be looking at whether or not there'll be other rights necessary. And in the life sciences, it's a crowded space. There's often other rights that are going to be necessary. And trying to line up access to that as you go through the research and development is really important. So the owner is able to enforce their rights, and they do that at their own expense, their employer's expense, in civil actions for patent infringement. If somebody were to be making what you have claimed, then you would be able to prevent them from doing that. It's an expensive process. And getting into the details is really beyond the scope of this because we're going to just do an IP overview here. But I think the important part is that a patent doesn't guarantee commercial success. It allows you to incentivize the investment that may lead to commercial success. So what did we do with question 6 on patent rights? Well, we're going to want to talk about the type of filing. When we went through the question, that was one of the specifics that they wanted you to list. And again, that's because you're indicating where you're at in the patent life cycle. If you have a provisional filing, it's right now, if you were to do it, it would have a series of numbers that look similar to the example there. And what that does is that establishes a priority date. That says, I came up with this idea, and I filed on this idea as of this date. And that is a placeholder application. It's not examined. And within a year, you're going to need to convert it to file another application, which would either be perhaps a U.S. application or a PCT application, maybe both. A PCT application is something that is a international placeholder. So the provisional is a U.S. placeholder that will lead to an international placeholder if you'd like to file with the Patent Cooperation Treaty an application. And that will also not be examined. There's a search report that comes from that to give you some sense of where the claims may overlap with other prior art, but that is also not an examined application, and it has to be converted, or what we call nationalized, filed in the individual countries where you'd like protection, with 30 or 31 months after the first filing date. And why does it have to be filed in each of the countries? Because patents are territorial. So if I have a U.S. patent, that only allows me to prevent others from making, using, selling, offering for sale, and importing the claim subject matter in the U.S. If I want to prevent people from doing that in Europe, then I need to file a European application and validate it in the various countries of Europe. So whether you're listing a provisional application, a PCT application, or a U.S. utility application is going to signify whether you're at one stage of the filing process or another. The U.S. utility application would be examined, and that's going to signify, depending on when the filing date of that is, where you're at in the process. You know, the various art units take different periods of time for patents to issue, but generally if somebody sees the utility application has just been filed, we wouldn't expect a patent for a number of years. If you've had a patent issue, then you'll have a different type of number that you'd be listing. When a patent issues in the United States, it's good for 20 years from the earliest filing date. And that would signify where in the development the technology would be able to have protection. There are various things that can extend or detract from the term of the patent, but somewhat beyond the scope of this presentation. So that's patent rights, and one of the things that, as you have a patent right, you're looking at, as we mentioned, are the claims. And so the grant application is asking for you to describe what types of claims you have. An independent claim is a claim that does not need any reference to any other claims that are listed in the patent application. So it would just be a sentence that would stand on its own. And those would be important to list because those are going to be your broadest claims. There may be more than one of them. There typically would be. Then as you narrow the scope, you get more specific about your invention, you add additional information to the claim, you are creating a dependent claim. So it would say, for example, claim number 2 would be the subject matter of claim 1 with some additional things, you know, wherein the compound is contains an antimicrobial agent or whatever that dependency would be. Those may not be as important to list. You know, the detail there is probably not as significant, but the independent claims give a sense to the reviewer as to where the metes and bounds of your invention would be. There's also the differentiator between whether or not you have a product claim or a method claim. So a product claim, for example, would be a composition of matter, you know, a new chemical moiety. A method claim would be a method of using a composition of matter. And so those claims have different relative value, and they also would suggest perhaps a dependency on something else. So for example, if you have a method of using a compound, but not the compound itself, that suggests to the examiner, well, who has the compound? Where might that be? And that would be something to address in your commercialization plan if you had that information. So there are 2 other types of patents. I've been focusing on the utility patent, and that would be the most common thing that we would see in the life sciences. But I really want to spend a second to make sure that you are aware of design patents and plant patents. Design patents in particular are useful, especially in the medical device area and in other areas where a utility patent is less likely to be able to, based on there being so much other prior art, to be able to issue. This reserves another form of protection, and it protects ornamentality, the way something looks, the aesthetic of your device. It doesn't protect the functionality, but this would be another way to say if you've come up with a novel syringe design, a dual chamber mechanism or something like that. It won't protect the mechanism itself in deploying whatever is in the syringe, but it would protect the look of a syringe in that configuration. These patents are for a shorter duration. There's just 10 years from the filing of that And something to consider as you look at your intellectual property strategy and discuss that with the Technology Transfer Office. Planned patents are more obvious in certain invention areas, but that is yet another form of patent right. And for the sake of looking at the overall landscape, I certainly wanted to mention that these forms also exist. Okay, let's turn to trade secrets. So we've left patents, which would allow you to preclude somebody else from making, using, selling, offering for sale, or importing your product. Now we're going to talk about trade secrets. I like to think about as being at one end of a spectrum, where you on the opposite end of the spectrum is general knowledge, the know-how that you have about your technology and your art area, the scientific endeavors that you just generally know. And when you know things, some of the things that you keep confidential. You don't share generally with the public. And then if you go to the opposite end from just general knowledge through confidential information, you land at the opposite end of that spectrum with a trade secret. And a trade secret is confidential information that would impart economic value. And in particular, we see things like processes and methods, and perhaps when I use this compound, it needs to be at a certain temperature, or other aspects that would allow somebody to take your technology, if they knew it, and be successful. Those are the types of things that maybe you know, but you have not told the public about, and that you would be able to leverage for commercial development. And often these are the types of things that perhaps you wouldn't be able to get a patent on, or would be easily reverse engineered, which would mean somebody could replicate it if they had your product in their hand. So these secret things, and you think of things like the formulation for Coca-Cola and those various types of things, which obviously impart economic value in remaining secret. Now, it's important to note trade secrets are requiring a higher level of due diligence to maintain than just confidential information. So anything that you would normally do to protect your confidential information, marking it, restricting access to it, and those types of things would obviously be necessary to maintain a trade secret. But then in addition, there would be a heightened level where you would be able to show that you have had a process, and through your Technology Transfer Office, you guys would work something out as to the way the institution prefers to protect things like this. But for example, if the trade secret's clinical data, how would you maintain the data? Who would have access to the data? Would it be on a public server? Would it be downloadable? Those types of things. Would help you evidence that you've maintained your trade secret. So with trade secrets, you don't go file those anywhere. You're obviously not disclosing them. The benefit is in them not being made public. Your trade secret is a statutory right that you have to prevent others from using it, and typically that's through a contract. For example, a confidentiality agreement may say you can use my trade secret information for this period of time for this purpose and no other. And if there was a breach of that, there would be the ability to say to the party who had breached, you've misappropriated, you've used my information in a way that you weren't permitted to do. And in the event that you've done that, I can stop you from doing that and seek damages. So this is a protection available only until the public becomes aware of the trade secret. So if there's not confidential information, then the trade secret would fall away. And even if the information is confidential, it would still have to have some economic value in order to qualify as a trade secret. In the technology areas that we're dealing with, that is certainly something that would most likely be the case. So what do you do if you have trade secret information? Well, obviously, when you answer question number 6, you're going to not list your trade secret information. Rather, you're going to characterize it. Is it a process parameter for manufacturing a compound, or producing a cell line, or media, or temperature aspects, or a variation of a technique? Is it information that would suggest what you wouldn't want to do when you're performing the technology? Often negative data and things that you would want to avoid are things that are falling into the trade secret strategy of protection. And so while this is perhaps less common a form of protection than patent rights for certain in the nonprofit research area, it is not unusual to see, especially with clinical data and other manufacturing and process parameters, there to be some measure of information on your technology that's protected by a trade secret. So there's an importance to consider that as you're filling out the application. It would be something that would be part of the commercialization plan, because it's easier to see this form of protection falling away because it becomes public. This perhaps is perceived as less valuable. It really would depend on what the substance of the information is that you're maintaining as a trade secret, and whether or not it's something that can withstand the need that otherwise would be there to develop the technology. Okay, let's turn to the third form of intellectual property, and we'll cover the last two more quickly than we have the first two. The copyright area is something that most of us are familiar with. It's protecting works of authorship we see from the Founding Fathers way back from the time of the Constitution in works that are fixed in a tangible media. And you know, obviously books and music and those types of things are the way that we interact with copyrighted subject matter, you know, from really the early stages of our lives. As we develop it as a form of intellectual property in the life science area, we often see it go beyond, you know, the typical and more traditional sense of copyright, and certainly in the software area, the imaging and other aspects of device functionality, we see copyright becoming an important aspect of the intellectual property strategy, commercialization strategy. Now, what you're going to protect with copyright is the literal words, the literal work, the software code that's fixed in that tangible form of expression. It's not going to protect an idea, a procedure, or process. And those are the types of things that would be protected more commonly under patent rights or by trade secret. So who would file a copyright? Well, we talked about the author, who is the one who first affixes the work into that tangible media. They would be the ones who would have the standing in the U.S. to file a copyright application. Now, typically they will have assigned, transferred, conveyed, obligated their rights to another, their employer or whomever's asked them to create the work. And so it would be that person who would, the research institution, for example, who would make that filing. Now, the filing doesn't have to be made. As soon as the work is affixed in tangible form, copyright exists through common law. So there is, at the moment that that is done, the ability to have a copyrighted work. However, if you would like to enforce your rights, you would register those with the Copyright Office. And so if you do register your work, what you would be able to do is exclude others from reproducing it, copying it, distributing it without your permission, performing it publicly, or making derivative works, displaying it publicly. And let me back up for a second on derivative works in case that's not intuitive. That would mean taking the software, for example, and doing another version of the code. So those would be the types of rights that you would be able to prevent others from doing if you held a copyright. Those have a much longer duration, as you can see from the slide, than would be available to patent rights, but you know, arguably less than trade secrets, depending on if you were able to maintain the information as a trade secret. And often there's multiple strategies and different forms of intellectual property covering the same technology. So what would we have as far as an answer for copyrightable subject matter? Well, what we're looking at is really tying whatever the subject matter that you're asking for the funding for with existing copyrights or with what you would perceive as being protected by copyright. So for example, if you're intending to develop some new imaging software as a component of what you're seeking the funding for, does the base code already exist? Are you creating a derivative work? You know, what's your strategy for how you would protect what you're intending to develop under copyright? You know, if for example, you are taking existing contributions that are out there in the science, you know, perhaps existing data on various indicators of a disease state and putting them together in a single test. You know, would there be a collective work, or would there be, you know, a compilation that you'd be pulling together? Just different things that you would want to think about and talk with your institution's technology transfer office as alternative strategies, or perhaps in addition to other technology strategies for protecting the rights that you're seeking the funding for, or that you already have protected as the background rights. Trademarks. So what do we cover with trademarks? You know, we bump into these every single day when we turn around and we see a word, a phrase, a symbol, a design, a slogan, some sort of combination that would distinguish the goods or the services that we are providing, you know, would identify the source of those goods. And so with trademarks, the person who would file would be the one who's identifying themselves as the source. So if I'm manufacturing something and I'm using it in commerce and I want people to know that it's mine versus my neighbor's, the neighboring company's activities in service or goods that they're producing, I'm going to trademark those goods or services. This use in commerce is important. It would be required in order to get a trademark protected. However, it is not necessarily required to file. You can file what's called an intent to use application to protect your trademark rights, and then over time would need to show that you're actually using it in commerce. So that would be, again, another way to signify a development process, where you're at in the development process as you complete the grant application. Trademarks do not have to be filed. There's also common law protection, and you'll see the difference between if somebody has a registered mark or is using the common law benefits of a trademark based on what is signified with the goods. So TM or SM would be an unregistered mark, and that would be in limited geographical use. You'd be able to prevent others from identifying themselves for similar goods or confusingly similar goods. However, if it's got the circle R, then that would mean that it's registered, and there are, you know, a couple of different ways that you can register a trademark in the United States, and what that would allow you to do when you've registered it is to prevent others from infringing, which would mean copying and identifying themselves as the source for those goods. So they'd be trying to pass off, for example, is how it's sometimes worded, their goods as your goods, and you will have developed goodwill in your brand. You know, if you go to the store, you want to get a certain brand of something. You don't want others to try to suggest that they're providing the very same product. And so when you have those various products, you, with your trademark, need to maintain and do quality control to make sure that there isn't that confusion arising in the marketplace. If there is that confusion and it's not abated, then what can happen is you will lose the trademark right that you have because it will become generic. And we can, you know, all think of examples, for example, Zipper and other things that were once trademarks that lost the trademark status because they lost their distinctiveness. So another form of protection, and how would that typically impact when you're doing the grant application? You know, this is a less common form, but it's not impossible to perceive of a term of art being identified with your research. You're the gold standard for this. Maybe it's a process that you've developed or a platform technology that people reference in the publications and that you anticipate going to market with as identifying this platform or this technology with yourself or your research team. So it's another form to consider. In summary, I want to leave you again with this idea that question number 6 should not be left blank. You know, we've just talked about a variety of ways that the question could be answered. But in the event that there truly is no current intellectual property, not even confidential information that's not published, you would, I think, want to address why that is, so that you could at least signify that you have a strategy for developing new intellectual property, and that if funded, what you would see as the forms of intellectual property and the ways that you would protect the technology. Because again, you're asking for an investment in you and in the technology, and in order to justify that investment, there would need to be some explanation of how it would be protected, and you'd want to show an appreciation for understanding intellectual property, understanding how to work within your institution for the technology transfer office resources and services that are available, and the strategy that's going to be necessary to take your technology from whatever the stage of funding is you're looking for now through some sort of a commercialization plan, which is going to require third parties, for-profit entities, to want to develop and invest in the technology, often on a global basis. So if there are further questions, please, I welcome them. This was a whirlwind through, and I appreciate that there may be some desire to drill down. Feel free to reach out to me, and I hope that we'll be seeing all sorts of depth and certainly further information completed in question number 6 Thanks so much for your time.
So thanks very much, Pam, for this excellent review of the details behind question number 6. Obviously, there was a lot of information there that each applicant can get some benefit from, but also a lot that would not be appropriate for some applications. But the goal here was to try to give the applicants a sense of the kind of detail that we're looking for under intellectual property in question number 6. If anybody has further questions for us on this, the best place to go would be to your center administrative group there, and they can help you with your application, and also Pam Cox would be available to answer questions as well through electronic communication.